Hello, and thank you very much for coming to our book launch. My name's Kim Bouwer, and I am co-editor of the book Climate Litigation and Justice in Africa. What we're doing today is we've brought together a few of our authors to talk about their work on the book and talk through their chapters with you. Unfortunately, because of teaching timetables and schedules, we don't have everybody here today, and we don't have everybody here live today. So we have a mix of presentations with a couple of videos that have been recorded by some of our authors who couldn't be present, but still wanted to talk about their work or share their work with you. So I'm going to chair today, and we're going to run through, just to give you an idea, this is the order we'll be presenting in. We're starting with Uzwazo Temere, who's going to talk through the themes of the book, then Tracy Lynn Field, then Daniel Iwona by video, then Elsabe Boshoff, Fiona Batt, Igorsa Ekator, Yunus Hassouni, and then Pia Rebelo. So those are the people you'll be hearing from today. We're going to start without much ado. I'm going to hand over to Uzwazo Temere, one of our co-editors. Uzwazo is an associate professor at Port Harcourt University in Nigeria, and he'll be talking through the themes of the book with you. Uzwazo, I'm handing over to you.
Yeah, thank you very much, Kim. So the title of the book that we're all launching today is Climate Litigation and Justice in Africa. I believe we all know that. And the aim of this book was to strongly present an African perspective to the pursuit of climate justice, especially but not only through the courts in the context of the emerging global scholarship with respect to climate litigation. On the whole, while the book acknowledges the fact that there are some similarities in the characteristics of climate litigation in the global north and in the global southern countries, it strongly acknowledges and stresses the fact that there is a distinctive feature of climate litigation and the pursuit of climate justice within the African continent. And at the core of this difference are the dissimilarities in the priorities, in the pressures, as well as the opportunities that are present or available for potential litigants in both the global north and in the global south. So in this book, it's divided into three parts. The first part focuses on legal tools, opportunities, and barriers to climate litigation in Africa. And then the second part pulls together articles that are focused on the rights-based approach to climate litigation in Africa, which approach seems to be the most favored, arguably, approach for pursuing climate justice within the continent. The third and the last part of the book pulls together chapters that talk about justice, equity, and activism, as a means for achieving climate justice and pursuing climate litigation within the continent. In these three parts of the book, we have a total of 14 chapters, apart from the introductory editorial chapter. And then we had 16 fantastic authors, whom I would like to thank. These authors reflected on the major theme of this book from a southern, western, eastern, and northern African perspective to climate litigation in the continent. And this is one of the strong points of this book, because the status of climate litigation in the continent is not uniform. And so it was important for us to reflect this diversity as contained in the book. And also we had chapters reflecting on the theme from both a common law and civil law perspective. And if you look at the pool of our authors, you can find at least an academic, a judge, an independent researcher, a PhD student, an attorney, and an environmental or climate activist. So all this contributed to the richness of perspective that the book indeed reflects. So in putting together this book, I would like to thank the editors of this particular book for the hard work spanning more than a year, especially, if I may, our lead editor, Dr. Kim Bouwer, for dragging the rest of us along sometimes when motivation seems to have been low. And also, I would like to thank the Foundation for International Law for the Foundation for International Law for the Environment, for funding the open access for this particular book. Then I would like to thank Bristol University Press for publishing and the hard work of walking us through the process. And lastly, I would like to thank LSE, particularly the Graham Research Institute on Climate Change and the Environment, for hosting this particular event today. Thank you very much.
Okay, thank you so much for that introduction. So that's just some insight into the structure of the book and a bit about the journey that we had getting where we are. And thank you for the thank yous. You've been great to work with. Okay, so now we're going to talk through some of the chapters. I'm handing you over to Professor Tracy Lynn Field, who is a professor at Wits University and the Claude Lyon Chair of Water Stewardship. Have I got that right? And Tracy has a chapter to share about assessing a thematic approach to climate risk in African climate litigation.
Thank you, Kim, and thank you everyone for joining today. Yes, I was a co-editor of this beautiful volume that is the African continent on its cover, actually, and then the author also of a chapter which I'm pleased to share today. And just to say that it is a celebratory occasion. It's been a long journey that started in a coffee shop in Johannesburg called Motherland, pre-COVID. So it's been a while. So essentially, my chapter is titled Towards a Risk Thematic Approach for Climate Litigation in Africa, is both epistemological and methodological in its orientation. And it's epistemological because it notices that the epistemological choices relating to how climate litigation has been defined, and that is a choice that has centered what I call climate visibility, that this choice has had two important effects for the African context. So the first effect is that it has positioned Africa on the margin of climate change litigation, which reflects and reconstitutes the continent's peripherality. And the second effect is that it has resulted in a case archive with a mitigation and a global north bias. This is not to say that the extensive labor and commentary that has gone into assembling these databases is not valuable and important, also for the African context, but just that it has had these effects. So to develop my epistemological arguments, the first part of the chapter outlines the salience of this climate visibility criterion in definitions of climate litigation, with a view to underscoring how this choice supports the sophisticated knowledge structures that have developed around databases like the Sabine Center's database and the Grantham Institute. And just to sort of illustrate, this is just something I picked up today. We even have a court case in South Africa that advocates adopting the protocols of the Sabine Center, which is quite remarkable. Then, still within the domain of the epistemological argument, the chapter then posits climate risk as an alternative choice, an alternative basis for identifying climate litigation in Africa. And this is linked to an important caveat and one critical insight. So the caveat is that climate risk is not the same. It's not the same the world over. And there's already ample evidence, and the knowledge is already actually organized in that way, that climate risks are region and sometimes even locality specific. So droughts, floods, pestilence, and so on are not evenly spread. And that climate risk tends to be framed in these terms. The insight is that climate risk has already manifested and materialized, which means that various legal institutions are already grappling with and evolving alongside and in the face of climate change. And so another effect of the hegemony of the climate visibility approach is that it invisibilizes these evolutions. So the starting point is that if we're going to understand climate risk in its regional specificity, we need to start with climate science. It needs to be firmly grounded in climate science, in the reports of the IPCC. And so the chapters linked between the epistemological and the methodological parts is really just to present an outline of the key climate risks facing Africa and Southern Africa in particular. From that basis, it then moves takes a methodological turn and distills the main keywords relating to risk, climate risk in Southern Africa, which are keywords like drought, water security, veld fire. And it applies these keywords to an open access database of legal materials in Southern Africa, and then there's the Southern African Freedom of Legal Information Institute, the SAFLI database. And it contrasts the hits obtained by using these keywords, contrasted with keywords like climate change or greenhouse gas. And the results of this experiment are presented in table 2.3 of the chapter. So one of the interesting findings is that there are double or even triple the number of hits for flooding and drought respectively, compared to a keyword such as climate change. And this suggests that climate risks, these regional climate risks, are leading to conflicts that are coming before the courts. Honing in on the drought hits, for example, it was apparent that more than 50% related to the period 2014 to 2019, which is the time span of a significant El Nino event in Southern Africa. And yet, I haven't been able to find a single literature contribution that discusses these cases or the adequacy of drought governance mechanisms in the face of the climate crisis in Southern Africa. The final part of the chapter then illustrates the value of a climate risk thematic approach by discussing 3 cases within the drought litigation hits. The first case deals with a chicken farming operations resistance to a measure called watershedding in a municipality. And the remaining 2 deal with judicial reviews of the state's handling of requests for drought relief on the part of the rural poor, not farmers, but the rural poor. So in doing so, it shows how existing laws and institutions, just presenting a sample of how these existing laws and institutions and which laws and institutions are already being tested and are evolving in the face of climate change. So in conclusion, I'm hopeful that this chapter will be a foundation for developing an alternative set of databases, alternative knowledge structures that really serve African scholars and African policymakers as they grapple with how law's role in adapting to climate change alongside mitigation. Thank you all, and thank you, Kim.
Thanks so much, Tracy. That was interesting as always. And again, this work will be continued as part of the Claude Leon Chair, I understand, amongst all the other things you'll be doing. I forgot to mention earlier, we do have a Q&A function. So at the bottom of your screens, there's a Q&A box. If you have questions to ask, please do ask them there. But also, everyone's available. We're academics. If thoughts come to your mind later, please get in touch with any of us if you want to ask anything about the work we're discussing. Okay, so our next presentation is a pre-recorded video presentation from Daniel Awona. He is online, but traveling, so there's poor connectivity. So he might be able to answer questions if you have any, but he's pre-recorded a video, which we are now going to upload and play. Here he is.
Hi everyone. Sorry to not be able to take part to the webinar with you all, but I hope that this video will provide you with key information related to my chapter. Since I have been following the development of climate change litigation around the world, I've been surprised to find that there were no reported cases in French-speaking civil law African countries. I checked again the Sabin Center Climate Change Litigation Database before this webinar to verify if something changed since the publication of my chapter, but it remains the same. Considering this situation, I was wondering if there were legal barriers in these countries that prevent the development of such cases. Furthermore, I was asking myself, if barriers exist, are there possibilities to develop these cases in these countries? And I chose my country, Cameroon, as a case study as uh, considering the influence of civil law in this country. And my answer to these questions is yes, 100% yes, because there are legal barriers, but there are also possibilities, there are also opportunities to develop climate cases in Cameroon. Um, One of the legal barriers I identified in the chapter is related to the capacity and standing of CSOs. The Cameroonian constitution states that everyone has the duty to protect the environment. Thus, any natural or legal person have an interest in acting in environmental matters. But the law on the environment states that the capacity and standing of legal persons such as CSOs is conditional. They should be approved by the ministry in charge of the environment to be considered to have capacity and standing to file a case. The provision of this law led judges in many cases, and also in the case Association Club HSE versus the state of Cameroon and Gaz du Cameroon, to declare inadmissible the application on the violation of rules related to the public participation and consultation prior to the construction of a gas pipeline. This case could have been framed on climate change grounds and would have been reported for sure on climate litigation databases, but it was not. And this case is similar to the Save Lamu case in Kenya, but there is no mention in the case of climate change. This restriction of capacity and standing of CSOs also explain why most of the environmental cases reported in Cameroon are not filed by CSOs, but by the administration in charge of the environment or any natural resources. And it is evidenced by the forestry and wildlife litigation database that we at FLAG, Field Legality Advisory Group, a Cameroonian CSOs, that we maintain, and we track this litigation in the region, in every region of Cameroon, and we are currently working on a Congo Basin databases on forestry and wildlife litigation. Even though there are barriers, Cameroonian CSOs use other tools to seek climate justice, such as the independent monitoring of natural resources. It consists in monitoring the management and the exploitation of natural resources. Independent monitors analyze official documentations related to the management of natural resources, and they also observe infractions in the timber, mining, wildlife exploitation, in the export or in the transport of these natural resources. For example, FODER, which is a national NGO, reports their reports led to the seizures of timber, temporary suspension of logging titles in Cameroon. Flags work also on as independent forest monitor in Cameroon, and help other CSOs around the Congo Basin to to carry out independent forestry monitoring missions. And our work on forestry and wildlife litigation in Cameroon help identify key problems in the management of litigation in Cameroon, such as the non-respect of procedural rules for the settlement of forestry disputes. Concerning climate change, FLAG contributed to the development of a RED Plus independent monitoring methodology in GRC. And talking about the possibilities to develop climate change litigation in Cameroon, these possibilities could be related to the identification of claimants and the type of litigation. Um, when we look at the case Commune de Grande Sainte versus France, uh, we could have similar cases in Cameroon because cities and regions could be that are particularly vulnerable to climate change could also seek the annulment or uh, of act of the central administration for excess of power before an administrative judge. Considering that any litigation and activism related to forestry is part of the African model of climate litigation, the ministry in charge of forestry and wildlife in Cameroon could be supported in legal proceedings involving illegal forest exploitation by companies or natural persons in order to highlight the consequences of this infraction on carbon sequestration by the forest the, by the forest as extending carbon retention in harvested wood products. As many independent forest monitors in Cameroon signed a MOU with the ministry in charge of forestry and wildlife, the reports produced by independent monitors could be used as evidence during trial. And I think we should take advantage of the work of CSOs to strengthen their capacities in climate change issues so that they could be better equipped to monitor climate change issues, and that report could be used during litigation. So I hope I didn't take too much time. That's just key information I wanted to share with you for this webinar. Thank you all for your kind attention, and hopefully see you soon. Bye.
Right, thanks very much for that. I forgot to say, sorry, excelling in my job as chair, that Daniel's full name is Daniel Almal Owona Mbaga, and he's a PhD candidate at the Catholic University of Central Africa. Actually, he's just finished his PhD and is an advisor to Field Legality Advisory Group in Cameroon. Okay, next up, we have Elsiba Boshoff. Elsiba is a PhD student, let me just check I got this right, PhD candidate at the Norwegian Centre for Human Rights and worked for a period of time for the African Commission. Elsiba, I'm handing over to you.
Thank you so much, Kim, and good afternoon to everyone. So my chapter is in part 2 of this book on rights-based approaches, and it's entitled The Prospects and Challenges of Litigating Climate Change before African Regional Bodies. So arguably, to date, no cases directly focusing on climate change have been brought before the African regional human rights bodies, which are the African Commission on Human and People's Rights, the African Court on Human and People's Rights, and the African Committee of Experts on the Rights and Welfare of the Child. However, I argue that it is possible to say something about the prospects and the challenges of successful climate litigation before these regional bodies, based on the norms and the substantive rights contained in African human rights instruments, also the formal criteria for bringing cases before these bodies, the previous jurisprudence of these bodies that can shed light on how they might argue in climate cases, and also the other ways through which they have communicated on the climate crisis that could demonstrate their receptiveness to climate cases. So my chapter is divided into 5 parts. After the introduction, in part 2, I look at some of the core human rights norms underlying the African human rights system, what Matua has referred to as the African human rights fingerprint, and the implication of these norms for successful climate litigation. And I conclude that regional norms open pathways to climate litigation in the region through providing, for example, for justiciable socioeconomic rights, as well as collective rights, providing strong obligations on duty bearers to respect, protect, promote, and fulfill human rights, strong norms around the protection of children's rights, and also the possibility of individual and also corporate duties. In part 3, I look at the substantive provisions in African human rights instruments that could serve as the basis for bringing climate cases, and also the way in which human rights bodies are putting in place the building blocks for dealing with climate change through both its jurisprudence, but also its non-jurisprudential developments. So I look at some of the case law of the bodies, for example, on environmental rights, on indigenous people's rights, and also at some non-jurisprudential engagements with climate change, mainly by the Commission and the Child Rights Committee, through the adoption of resolutions, studies on climate change and human rights, and also the establishment in 2020 of a working group on children's rights and climate change by the African Children's Rights Committee. And so I argue that these normative pronouncements and these other developments indicate that these human rights bodies do take the impacts of climate change on human rights seriously. Then in part 4, I look at some of the formal requirements for bringing cases before the African human rights bodies, including admissibility criteria, rules around standing and jurisdiction. And then I conclude by assessing the opportunities and challenges of litigating climate change at the regional level. And I argue that despite African countries not necessarily contributing as much to greenhouse gas emissions, the African human rights system is an attractive forum for climate litigation, firstly because it allows for flexibility around standing and exhaustion of domestic remedies, and also that the human rights bodies already, through their normative statements, have indicated that they take climate change seriously as a threat to human rights. There are also some limitations. For example, there are barriers in bringing cases before the African Court. But I think that the broad standing before the other 2 bodies arguably make up for this to some extent. And also the fact that African states in most cases are, of course, not directly responsible for causing climate change. However, I argue that they do still have positive obligations to, for example, hold corporate actors accountable and to take positive steps to ensure climate adaptation and resilience of the communities within their jurisdictions. So I think in terms of the contribution of this chapter, it is somewhat distinct from other writings in this area in that it focuses also on the African Child Rights Committee, in addition to the other two human rights bodies that most writers focus on. It also focuses on African norms, so the distinct African human rights fingerprint. And I think it's relevant in that it tries to identify some of the kinds of climate cases that it would make sense to bring before the African regional human rights bodies, and also the kinds of remedies that they would be able to grant in a meaningful way. For example, orders for legislative reform, implementing of existing laws and policies by states, ensuring participation and consultation, and also some concrete steps in fulfilling their positive obligations to protect against the impacts of climate change, such as building of seawalls. Thank you very much.
Thanks very much, Elspeth. We're passing now to Fiona Batt. Fiona is an independent consultant who works mainly in Tanzania and Kenya. Where is she? There she is.
Good afternoon, everybody. Can you hear me? Can you hear me? Okay. First of all, I'd like to say thank you so much to the editors for inviting me to be part of this project. It's been a great journey, and I'm just so happy to be part of that journey. My area mainly is in relation to the protection of Indigenous peoples' vulnerable resources globally. And my chapter is a culmination of an idea I had in relation to the chatter about how helpful the traditional knowledge, or as I called it, meteorological traditional knowledge, could be to the scientific community if Indigenous peoples were able to share that knowledge. And that thought led me to the fact, wow, this is yet another vulnerable resource that may be taken without consent or without any benefits to the actual guardians of this knowledge. The PowerPoint. So Indigenous peoples of the African continent, although victims of climate change, have accumulated meteorological traditional knowledge over generations and are ideally positioned to offer their expert MTK to the scientific community. And Indigenous peoples globally have articulated this. And increasingly, we know that MTK can contribute to climate change adaptation and mitigation. Therefore, this chapter seeks to identify legal avenues to preserve and equitably share the MTK of African Indigenous people in order that it can be used to support the development of strategies to tackle climate change in a manner that will not cause cultural harm to Indigenous peoples. I use the term cultural harm. A definition of cultural harm you will not find in a legal environment, but Indigenous peoples have used this term. And in my chapter, I give some examples from Australia and America in relation to Indigenous peoples, stating what cultural harm might be. But however, of course, I don't come from the African continent, and I'm a non-Indigenous person, so therefore I can't really say how the theft of MTK in relation to Indigenous peoples would cause cultural harm, but I think that's for other writers to discuss and expand, and not for me to give my view on that. So thinking about legal avenues to protect meteorological traditional knowledge of African Indigenous peoples, my chapter proposes that the profile, vulnerability and value of MTK could be included in customary land rights cases under the African Charter on Human and People's Rights, before the African Court on Human and People's Rights, and the African Commission. So in my chapter, I specifically look at the Indorus case and the Mau Forest case. I particularly love the storytelling that you find in these two cases. And for many years, I've been drawn by the storytelling in the African court cases and the African Commission cases. So these cases involved semi-nomadic indigenous peoples, and I go into some depth in the chapter about why these peoples have this valuable MTK, their lifestyle, which is under threat, lends itself to generational meteorological traditional knowledge. However, if you read through these cases, one in the commission and one in the court, you won't find any reference to climate change. However, you'll find references to the guardianship of valuable biodiversity, the intergenerational knowledge passed down because of certain religious beliefs that have protected the environment. In these particular cases, a number of articles from the Charter were raised, and in the book, in the chapter, I just draw on three: the right to culture, the right to practice religion, and the right to development. And I'd like to further my research to see if these rights and other rights in the African Charter could embrace more readily MTK and climate change. And I'd hope that in the future cases will be able to draw on African Charter rights and embrace the issues with climate change and raise the profile, and also link it to if we lose, or if these people lose their customary lands, globally, we're going to lose also, or humanity is going to lose this precious intergenerational knowledge. And then I also include, I use the term backstop in my chapter, which if you look it up, if you look for a definition, it's sometimes called a high fence. The two international human rights principles of consent and access to benefit sharing So I argue in the chapter basically that the profile can be raised in future cases before the Commission and the African Court, and combined with these principles of informed consent and access to sharing, this is an optimistic view, hopefully raise the profile of, yes, meteorological traditional knowledge, climate change, but also customary land for future generations. So that's the nub of my chapter, really. Thank you so much. Okay, I didn't have the last slide, but that's fine.
Do you want to speak to the last slide?
Yeah, can I? Because I mentioned you in that as well.
Go on then.
That's quite good. So as I just said, access to benefit sharing and prior informed consent can go hand in hand with customary land cases. So this came from some work of Kim's, and this is a quote, I believe: "Central to benefit sharing are the issues of social justice and inequality between resource providers and those who commercialize these resources." So I suppose that encapsulates the thought behind the chapter, that it's okay for someone to give a resource as long as it's given freely and there are benefits for the giver. And if you look at consent in the Inter-American Court and the African human rights system, you'll see that consent can be freely given, but it can also be withdrawn if the person who's been given something disrespects that gift. And also in the Mau Forest case, the African court stated that consent must be given in accordance with the Oyak people's customs and traditions. And in addition, it must be given freely and can be withheld. So thank you so much.
Thanks so much, Fiona, and thanks for the plug. Always appreciated. Okay, so our next presenter is Igosa Ekator, who is with us. I was going to say in person. We're all live. Who's with us live? Igosa is a senior lecturer at the University of Derby in the UK.
Good afternoon. Thank you, everybody, for the invitation. Thanks, Kim and the other editors, for a job well done. My chapter, my co-edited chapter with my colleague, Dr. Eduardo Kumagba, my chapter is titled Climate Change and Multinationals in Nigeria, a Case for Climate Justice. So in line with the theme of the book, in trying to conceptualize or redefine what climate justice and climate litigation means from the African context. So what we tried to do with the book was to look at previous some of the relevant environmental litigation, environmental justice cases in Nigeria, such as the Gbemre case and the recent Center for Oil Pollution case, and try to analyze those cases from a climate sort of justice lens. So the argument is that in many countries, many extractive countries in Africa, there's a very strong connection between the quest for climate justice and the quest for environmental justice. The same environmental justice NGOs are still the same NGOs at the forefront of promoting climate justice on the continent. So the idea was to basically say there was a direct link, a direct connection between environmental justice and climate justice. So if you look at the Center has got to two Nigerian cases, I think, the Bemre case and Center for Air Pollution case. The Bemre case was a federal high court case that was decided a couple of years ago, and the Center for Air Pollution case was a case that dealt with access to liberalization of local standard for environmental NGOs to basically institute cases on behalf of victims of environmental justice in Nigeria. So we try to use climate justice in our chapter. We believe that climate justice is a variant of the environmental justice paradigm. So we try to use climate justice as a means to evaluate strategies to improve access to justice and protect climate change victims in Nigeria. So in Nigeria, prior to 2021, there was no explicit or standalone climate change act. So a climate change act has been developed. So we also argue in a chapter that on the basis of the recently enacted climate change act in Nigeria, there's now a possibility of explicit climate litigation cases. The argument we made in our paper is that even though there are no explicit climate litigation cases in Nigeria, depends on how you define and how you extrapolate the meaning of climate litigation from the African context. We're able to analyze existing environmental justice cases to see them as climate litigation cases. So we also argue that MNCs also need to be held accountable. MNCs also need to play more sort of hands on deck role, trying to ensure they engage in adaptation and mitigation in Nigeria. So one of the sort of the innovations or originality of the paper was that we basically use the three dimensions of climate justice that you can get from the same three dimensions in terms of procedural, in terms of recognition of justice. We apply the three dimensions of climate justice, use that to look at the two cases we analyzed. So we're able to see that if you apply the dimensions of environmental justice / climate dimension of climate justice to these environmental justice cases in Nigeria, can actually extrapolate climate issues from those cases. So we're able to look at the Center for Air Pollution case using the three dimensions of climate justice. We're able to look at the Bemre's case using the three dimensions of climate justice as well. So the takeaway from our paper is that environmental justice can be a tool to climate litigation, rather can be a tool to ensure that climate justice is ensured and protected, and there's improvement to access to climate justice in Nigeria. But there's a lot that needs to be done. There's a role for the judiciary as well. Even up to now, there appears to be a lack of knowledge of climate justice issues among some of the Nigerians of judiciary. In terms of scholars and lawyers in Nigeria, there appears to be the knowledge of climate justice and litigation is not really what we're supposed to be. So from our perspective, we believe that, yes, unlike what a lot of scholars say that there are few climate litigation cases in Africa, we believe that there are climate litigation cases in Africa, and we can actually reconceptualize existing environmental justice cases and use the climate justice lens to actually analyze those cases and sift out climate justice issues in those cases. So that was what my chapter was all about. Thank you very much.
Thanks, Igosa. Okay, next we have another video. Again, I don't think, no, the next video, questions be difficult because they're not here, but could be emailed if you have questions. So this video is by Yunus Lazrak Hassouni, who's a professor of law at Hassan University of Setat. His co-author is Riyad Fakhri, who's a director of the same center. Neither of them were able to attend, but they wanted to share their chapter anyway, so we're going to watch a video, which should be appearing now. Okay, here we go.
Hi, good afternoon, everyone. I hope that you are doing very well. I am Professor Yunus Lazrak Hassouni, Professor of Law at the Hassan First University of Setat, Morocco. I speak on behalf of myself and Professor Riyad Fakhri, who was unable to join us today due to our professional commitment. I'm very happy and honored to take part in this event, which marks the launch of our collective works, which is already a great success thanks to the efforts of our publishers. On this occasion, I would like to sincerely thank Kim, Oswazo, Tracy, and Admiro for their great efforts. Without them, the success of this magnificent project would not have been possible. Me and Professor Riyad, we have the chance to participate through a chapter on law and climate change in North African country, Morocco as a case study, answered on the third part of the book about justice, equity, and activism. Actually, we choose to focus our study on Morocco law because the country has been a leader among the North African countries by reviewing its public environmental policies and incorporating climate change to combat global warming and contribute to climate heat mitigation or adaptation. Morocco has also adopted a climate change policy and sustainable development strategy to strengthen the legal and institutional framework to meet the requirements of the United Nations Framework Convention on Climate Change, the Protocol of Kyoto, and finally the Paris Agreement. Matter of fact, our study showed that although Morocco has begun to incorporate climate change into its legal system, climate litigation has not evolved to the degree observed in the global north and some African countries like Nigeria, Kenya, and Uganda. No climate change disputes have been brought before the Moroccan judiciary. This leads us to seek to identify the reason and whether it is due to the Moroccan climate change legal and institutional framework. We focus our studies on Moroccan law and how is taken this into climate change consideration, and we turn to difficulties that prevent the development of climate change litigation in Morocco. The study showed that Morocco attached great importance to the protection of the environment, including a section of the legislative handling on climate and its change. This is reflected in a large number of legal texts dealing with the issue and the number of institutions in charge of the implementation of public climate policies. In Morocco, we must make the distinction between the legal provision prior to the enactment of the Environmental and Sustainable Development Framework Law of 2014, and the law issued after this framework. After this law, the Moroccan legislature has demonstrated a growing commitment to the handling climate change by passing several laws pursuant to the framework law, including, for example, water law for 2016 and law environmental assessment of 2020. This law demonstrates the priority given to the climate change and the promoting sustainable development in Morocco. We also find multiple institutions mandated to monitor and track the implementation of this provision. The role and limits of the action of this institution are clarified in the study. And of course, the main issue or the main idea that we tried to highlight in our studies was the challenge in preventing the development of climate change litigation in Morocco. We try to outline the reason behind the limited progress of climate litigation in Morocco. At the outset, it should be noted that the absence of climate litigation may be attributed to a lack of collective awareness of the legal avenue, and as well as the peculiarities of Moroccan legal system, which is deeply rooted in civil law tradition. And this question of standing, which refers to the set of requirements that plaintiffs must meet to demonstrate they are entitled to bring a claim before the court. So it is very important to have an explicit text that states clearly how to claim the right to live in a healthy environment and how we can bring a case about climate change before the judiciary in Morocco. This was our chapter, what our chapter tried to highlight. We try also to highlight some recommendation likely to allow the development of climate litigation in Morocco. I do my best to do to bring all information in 5 minutes. It was quite challenging for me. So sorry if I speak very, very fast, and I hope that was clear. And again, many thanks for this opportunity, and maybe we have the chance to meet in person and discuss further the climate litigation in Morocco and the North African country. Thank you very much.
I feel I want to say thank you, even though you can't hear me. Thank you so much, Yunus. Okay, we have one more speaker who is Pierre Rebello, who is here. Pierre Rebello is a lecturer in law at City University in London. Where is she?
I'm Mia Kim. Can you see me okay?
Yes,
Can you
I
hear
can see
me?
you.
Fantastic.
Over to you.
Thank you, Kim. Well, first of all, it would be remiss of me to not mention my brother, who is now Dr. Xavier Rebello. At the time of writing this, he was still a PhD candidate. But I needed Xavier's input because it's been quite some time since I've studied South African constitutional law, and certainly a long time since I've studied South African environmental law. So Xavier's input was very much needed in this piece. But really, due to my own background in private law, particularly contract law, I have become very interested in the new and emerging litigation risks for private actors. And this is predominantly because contracts are about managing risk. And we know that climate change is offering us a new host of physical, reputational, and of course, legal risks for private actors. So in addition to the better known torts cases that I know, Kim, you have written quite extensively on, there are also developments with the number of greenwashing claims that are emerging, particularly within financial markets and advertising. And we're also seeing claims now being based in company law against private actors. And these have had varying degrees of success. We know, for example, the very recent case of Client Earth versus Shell Board of Directors was unsuccessful here in London, was argued before the High Court, and really Client Earth failed to show that the directors of Shell had breached their legal duties under the English Companies Act for failing to plan for an energy transition. So while most of these cases are taking place in the global north, I couldn't help but really think if perhaps there could be greater prospects of success for such claims within the global south, particularly considering we have progressive constitutional dispensations that recognize the horizontal application of environmental rights. Now, I'm not saying that Client Earth's only downfall was the absence of a global south transformative constitutional context, but the question stands, really, would such claims against private actors show even more promise in an African or particularly in a South African context as far as company law is concerned, due to the broad array of considerations that can be taken into account for directors' duties? So obviously, being a researcher of private commercial law and this being of interest to me, I was very much aware that I needed some knowledge on South African environmental law, as well as environmental governance, more broadly speaking. That's why I asked Xavier if he would very kindly offer his expertise and help contribute to this piece, particularly focusing on private litigants and private defendants. So given that we are evaluating whether there are any significant advantages given by constitutionally enshrined environmental rights, our starting point was looking at the very recent wave of rights-based litigation within the global north. So the focus here when we were looking at global north climate litigation was particularly on one strategy of climate litigation, and that was rights-based private litigation. So rights-based litigation is used broadly to encompass cases which are founded on fundamental rights, as well as those that use rights as a reflexive interpretive tool. And our findings were that there appears to be a very clear judicial mandate for European courts, or I should say some European courts, to interpret the private law using human rights and to consequently consider the impacts of climate change on such rights. However, the horizontal application of human rights within a European context remains very much indirect, whilst environmental or climate change claims have centered predominantly on other rights, such as the right to life, property, and private and family life, not a right to healthy environment. So a climate case invoking a specific environmental right is yet to be tested, mainly for the reason that the European Convention on Human Rights does not contain an explicit right to clean and healthy environment. So arguably, certain African constitutions could possibly achieve more here in respect of rights-based arguments, as they not only recognize a specific right to a healthy environment, but also permit direct horizontality in addition to indirect horizontality, namely invoking rights adversely impacted by climate change directly against private parties, as well as interpreting the private law accordingly. So we did look at some rights-based cases within Kenya and Nigeria that invoked horizontality using rights-based arguments. But what we found within South African case law is that South African case law is evincing a robust constitutional rights framework, which interprets climate change to directly impact on constitutional rights. Although it is worth noting that direct horizontality in South Africa has not always been a straightforward matter. Under Section 8.2 of the South African Constitution, the Bill of Rights is binding for natural and juristic persons, so it therefore casts quite a wide net of duties on private actors to respect the environmental right. However, it seems that legislation and the development of the common law remains the preferred way to secure this. But we notice that the line between direct and indirect application is somewhat losing its relevance. And that is because of this notion of thick environmental constitutionalism, which employs a right-based approach to environmental governance by treating procedural rights and the substantive environmental rights as interrelated and mutually reinforcing in a number of ways. And we are also seeing the horizontal application of the environmental rights through non-environmental legislation, which is perhaps best illustrated by the ArcelorMittal case. Now, the ArcelorMittal case confirms that within a South African context, the notion of social corporate responsibility must be directed towards social justice as informed by a constitutional environmental mandate. So namely through this idea of horizontality and the application of rights. Also, the Stilfontein case interpreted directors' duties, specifically within the company law context, as entailing the notion of corporate citizenship that we see in the King Code, and found that it is in the best interest of a company to act in a socially responsible manner. And in this regard, the court did recite the King Code with approval, saying that a good corporate citizen is increasingly seen as one that is non-discriminatory, non-exploitative, and responsible with regard to environmental and human rights issues. So most notably, the court here substantiates its stance on the basis of constitutional values and declared that allowing the directors to resign, therefore avoiding responsibility for environmental degradation, simply cannot be permitted in a constitutional democracy, which recognizes the rights of all its citizens to be protected from the effects of pollution and degradation. So therefore, it was our finding that the Bill of Rights can be used to broaden the statutory scope of directors' duties, consistently with the South African judiciary's commitment to transformative constitutionalism. And this entails the influence of the overarching values of the Constitution on the legal culture of interpretation to align it with the normative value system. And obviously, where legislation does not do so, the common law must be developed to give effect to the rights. So the South African Companies Act provides a particular example of how directors' duties may be interpreted to pursue rights-based arguments in interpreting common law duties. And this is coupled with the granting of a generous locus standi for those seeking to protect environmental rights, and also with the broad standing offered by the Companies Act itself. So ultimately, the judicial developments that we discussed in this chapter confirm that Africa, and in particular South Africa with its constitutional dispensation, are ripe for the advancements of rights-based arguments against private actors. And in addition to company law arguments based on statutory duties like the director's duties, we are also imminently ready for a greening of the common law. And this impacts on both private duties ex delicto and those duties ex contracto. So our opinion in this piece was really to put forward that we are of the opinion that although many of these arguments are not yet tested and they remain untried, South Africa is a really good place to test rights-based arguments because the constitutional dispensation shows promising prospects of success for some of the arguments that we are seeing emerging within a global North context. So I hope I managed to do that justice. I'm sure Xavier will tell me if I didn't. But thank you, Kim, and thank you for allowing us to contribute to this fantastic project. Thank you very much.
Thanks so much, Pia, and it's been an absolute pleasure. I'm quite sad it's over. Thank you, everybody, for your presentations. We do have some questions. I'm very mindful that Tracy has to leave quite soon. So, Tracy, I wondered, do you want to, if there are any questions you want to answer, strategies and arguments?
Thank you. Just one, and quite probing questions. There are a few other books there in the question. So I just want to say one thing, the avenues for future PhD research. I mean, I think there's an undiscovered treasure trove of cases about climate risk in Africa, in Southern Africa. I'm particularly interested in the drought cases, and in pursuing this with sort of interdisciplinary scholars have faced some pushback where people say to me, well, drought is just water management, but I think it's something quite distinctive. And we are going to be having a two-day workshop in June. Already have a special issue devoted to this. So I certainly think that drought, if you're in Southern Africa, that's something you should pay attention to in all its different facets and dimensions. And with that, I'm going to bow out. Thank you for everyone for their contributions today and everybody who listened. It's been great.
Okay, thanks so much, Tracy, and see you soon. I just wanted to, so we're going to just look probably for about 10 minutes at some of the questions. I just wanted to answer one because I saw a name that I've known for a very long time. I just wanted to say thank you for being here. So Dr. Andrew Renz, who I've known since I was a trainee at Wits, has asked a question. He says, are there any legal basis for persons or people to claim for loss and damage, or is that obligation solely between states? And Pia's answer just saying loss and damages claims are difficult in any context because of the difficulties proving causation. But what I would add is that in the book, there are several of our chapters that explore the possibilities for compensation claims, and they may not be directly for compensation, but they look at themes about local environmental pollution and its connectedness with climate change. The point being, in many African countries, these two happen very close together. And I would highlight in particular, again, all the chapters are great. They're all very, very worth a read. But the argument I just made about the closeness of the two comes directly from Egorsa's chapter, where he makes those arguments about how environmental and climate justice kind of fuse in the African context. But also Pia's chapter as well does speak to the potential for compensation claims, just not specifically loss and damage claims. And several of the others do as well. But I think the point also is a lot of the harm that's caused in African countries is not directly caused by African states. So the questions can be quite different in many ways. And that's what we sort of try to highlight in the book. It's not necessarily the same conversation as a lot of the as you hear in a lot of the climate litigation scholarship in the global north, the questions are different because the contribution and responsibility is different. So I hope that was helpful. I'm now going to pass over to Fiona, who has a question from one of my colleagues from Durham, Adebola Adeyemi. Thanks, Adebola, very much for coming. And Fiona, would you like to answer that question?
I think the question was asking me, is there a realistic way for Indigenous, a realistic and safe way Indigenous peoples can share their knowledge with the scientific community? I think experience tells us that when Indigenous people share, then they very rarely get fairly compensated for their knowledge. One thing I've added in my book in relation to, strangely, human remains is that and in relation to private law as well, I think there is a place for private law, you know, contracts, and educating non-lawyers, and specifically Indigenous peoples, in legal language and secure contracts, and if anyone else has got any ideas, then you know, just pass them on. I think it's a difficult area. There's all this knowledge here, and every day you're reading scientists talking about this knowledge as though they've discovered it, and yeah, backstops need to be put in place, basically. But what those backstops are, apart from the ones I've discussed, I don't really know. That sounds quite pessimistic, but
okay, thanks, Fiona. It is quite a there's no end to that question, I think. Thank you.
Exactly.
Thank you, Adebola, for coming and for engaging with us. There's another question. Thank you for the book. In looking at climate litigation in the Global South, what would we say are some of the key strategies or arguments that could enhance some of these types of cases for litigators? Does anybody present want to answer that? Or okay, so I can have a go at that. So sort of it's not just the focus of the book, but there are some aspects of the book where we look at, okay, which strategies work in terms of progressing litigation, in essentially stopping things happening or increasing ambition, whether it's for mitigation or adaptation. So, and one example, Nicole Lizet's chapter, Nicole is here, but she's not presenting, does look at the effectiveness of kind of focused judicial review challenges in the South African context. And she explores how those have been very, very effective in the particular context of South Africa, but also explores how the activism around those cases was instrumental in the success of those cases. So that's one strategy I would highlight, that what Joanna Setzer and I have called hit the target type litigation in some contexts can be very valuable. Another example highlighted in the book in terms of a useful strategy. So in Igorsa's chapter, he highlights his chapter, but his work more generally, he highlights how this persistent campaign of litigation in Nigeria, both locally and abroad, has adjusted the practices and functioning of energy companies working in the country. Still not as one would want, but better than it would have been previously. And again, the particular nature of the African Charter on Human and People's Rights, highlighted in Elsaba's chapter, does open avenues for basically unexplored avenues for litigation that have a huge amount of potential but just have not been used. And again, coming back to the point that Oswazo raised in the beginning, which is the question what we would want to use those, why we would want to bring applications to the African Commission. There's not really the same questions about African countries and a contribution to climate change, most African countries and a contribution to climate change, because most of them have not caused climate change. But there are questions that could be raised about adaptation, about protection of people, about migration, and also about the role of corporate actors on the African continent. And that's where some of these legal remedies would be useful. Anybody else want to answer that question?
Yeah, Kim, if I could just add to that, I can't really comment on what would be the most successful strategy of litigation and what would be the most, successful avenues of exploration in terms of advancing certain arguments. But I do think there is a lot of work to be done, particularly within the private law. Dr. Fiona Batt mentioned contracts. I think contract law is one area that is particularly underdeveloped when it comes to climate considerations. People seem to think that, torts is the preferred private law sister of contracts when it comes to pursuing damages for loss and harm caused by environmental damage or climate-related incidents and climate change more generally. But I think there are a lot of avenues here to explore in terms of litigation. Whether it is the most appropriate form of climate activism, probably not. But I think it's definitely worth pursuing. If the money can be raised and people are willing to try these things out before the courts, it'd be great for us lawyers to analyze those judgments afterwards.
Okay, thanks, Pia. And while your microphone's off, there is a question for you in the chat. Can you please share a bit more on areas of common law that would be needed to be developed for delict-based loss and damage claims? For anyone who's not South African, delict-based is fundamentally torts, although actually not the same remedy. I'm currently thinking about claims for future costs of adaptation, with the common law probably being limited in that the harm, in a sense, has not yet happened. Any thoughts welcome, but it feels like this, it feels like this common law development is key. And again, my recollection of delict, which is very, very rusty now, is that damage is not required in the same way it would be in a tort claim. So there's sort of possibilities there. But Pia, do you want to try and answer that? Or anybody else, feel free to join in.
I would have to refresh my rules on delict causation and damage, because I've been very much based within an English common law jurisdiction. But I can comment on the private law and common law more generally, because most of it, especially when it comes to things like contract, is very much premised in English law principles of contract. By and large, I think English law has retained its dominance, particularly in Commonwealth jurisdictions, when it comes to private transactions and private duties. I think when it comes to delict or torts, as we call it here, you have those issues of causation that those are quite hard to overcome, particularly when it comes to climate change. How do you prove where the loss lies? And then when it comes to contract law, which is what I can comment on because it's more aligned with my kind of work, is that contract law, with English contract law and common law in particular, is wholly inadequate to deal with climate considerations. It is incredibly formalistic and minimalistic, even in comparison to other Western jurisdictions. So I don't see much hope for the common law developing too much anytime soon within England and the jurisdiction of England and Wales, which of course has impacts for international commercial law more globally speaking. But I do think there is a gap there in research for needing to advance private law arguments and trying to drift away from this stagnation in the common law that we are presently experiencing, because there's a complete unwillingness to address external factors and social justice agendas. I think moralistic reasoning is still met with a lot of skepticism within private law. There's this underlying premise that the private law there just serves selfish private interests and laissez-faire capitalism. So there's a few hurdles we need to overcome in terms of how we think about the private law and what interests the private law serves.
Thank you for that. That's interesting on many levels. I have a question for Elsevier. This is from Engin Ferret. I hope I'm pronouncing your name correctly. Apologies if I haven't. Considering the diverse legal landscapes across African nations, what are your thoughts about the feasibility and potential impact of establishing a new set of standards for applying admissibility criteria thresholds before African regional bodies, particularly in the context of climate-related cases where a less stringent commitment to sovereignty might facilitate more successful outcomes? So essentially, what's the scope for relaxing admissibility criteria before African regional bodies? I would add, is it necessary to do that?
That's where I would probably start. And I don't think that we do need a whole new set of admissibility criteria. And I do try to, in my chapter, unpack a little bit how the existing admissibility criteria and also around jurisdiction is actually quite flexible and can be used in different ways. So one of the main challenges that we often see to climate cases is that we have to exhaust domestic remedies. And this is actually one of the areas where both the Commission and also the Child Rights Committee have been quite flexible in applying this criterion. So they've not been so stringent to say that if you're, for example, like the case before the UN Child Rights Committee, where the case was dismissed on the fact that they hadn't first gone to the various national courts. If we look at the jurisprudence from the African Child Rights Committee and also the African Commission, both of them have said that in the case of serious and widespread violations, where, for example, thousands of people would first have to go to a national court before coming to the regional bodies, or where several countries are involved in the litigation, where it would be very hard to go to all the different jurisdictions. In those cases, these bodies have actually said that it wasn't necessary to exhaust domestic remedies, particularly because this would have resulted in a prolongation of the process. And one of the exceptions, or the main exception to the exhaustion of domestic remedies, is where those remedies are unduly prolonged. And particularly in relation to children, the Child Rights Committee has also said that if we think about the life of a child as a child, every year counts as 6% of their childhood. And so we need to kind of prioritize those kind of cases. Just maybe, some of the jurisdictional considerations. One of the main challenges is also around material jurisdiction. Can we prove that this climate issue resulted in a human rights violation? And I think there, the normative statements from these human rights bodies are very clear. They do consider climate impacts to result in human rights violations. They've made that very clear. So I think the material jurisdiction aspect would also not really present a real challenge. And then finally, in terms of who can be held accountable, so this also a little bit goes to the question you were responding to before, Kim, on non-state actors. So, of course, the African Court, the African Commission, but also more recently the African Court have been very willing to hold states accountable for the violations committed by non-state actors. But there's also a growing normative development, not that strong yet, but trying to say that corporate actors could also be held directly accountable. So the African Commission, in its state reporting guidelines on Articles 21 and 24, tried to elaborate the individual duties that we have under the African Charter, to say that this would also impose individual duties on non-state actors, so that they can become human rights duty bearers. How this would look in the courts has not been developed a lot, but last year, September, there was a case before the African Court, the Lido case versus Cote d'Ivoire, in which the court actually confirmed that corporations can be human rights duty bearers independently from the state, and they draw on the UNGPs and also some earlier jurisprudence from the Commission. So in the main judgment, they don't go as far. So right at the end, they go back and they focus on the state. But there is a dissenting opinion that says, in this case, it was really the kind of case where you would want to hold the non-state actor directly accountable. So it seems there is even in the jurisprudence, the shift may be very close to happening, but it would be necessary to develop the modalities around how that would take place.
Okay, fantastic. Any other questions? So just in case anyone has a question, I'm just going to ask all the remaining panelists if they have anything that they feel they wanted to say that they didn't say, or that they would like to share before we wrap up. I'm not sure if the Q&A function, if I can see if somebody's typing, but I can't, it doesn't look like anybody's typing. So I'm assuming all questions have been answered. I hope all questions have been answered. So I think if there's no further questions and everybody said what they wanted to say, we could probably call it, I was going to say call it a night. No, it's the middle of the afternoon. We could probably say that's the end of the webinar. So I just wanted to say, firstly, thank you very much to the LSC for hosting this. Thank you for everybody who came and stayed to the end, or thank you everybody who came and didn't stay to the end. And thank you to all the panelists and presenters, both live and video recorded, and also Tracy who's gone. And finally, thanks to all the authors and all my fellow editors. And with that, I think we can call it a night.
Thank you, Kim.